Okay, so now we're going to talk about the Bill of Rights and the amendment process. The Bill of Rights are the first 10 amendments to the Constitution. We have to understand that the Bill of Rights were added through the amendment process to satisfy the Anti-Federalists. Remember, the Federalists and the Anti-Federalists fought over this Constitution, and to get enough Anti-Federalists to go along and pass the new Constitution, instead of sticking with the old Constitution, Articles of Confederation, they agreed to a Bill of Rights. And the Anti-Federalists won. They said, no, we want at least these rights enumerated, and which means numbered and written out, so everybody can see that these are your individual rights to protect you from the government. We call these your civil liberties. So your civil liberties are anything that's interpreted or are in the Bill of Rights. Okay. So, for example, freedom of speech is a civil liberty. However, equal treatment under the law in public school, that's not a civil liberty. That's a civil right. That's not actually in the Bill of Rights in the first 10 amendments to the Constitution. Okay. So the Anti-Federalists win this battle. The Anti-Federalists led by Thomas Jefferson win this. And we find out is Alexander Hamilton argued against this. His fear was that if you start putting amendments in there and listing things, that people will be so focused and obsessed with these amendments that that's all that they'll talk about. They'll see these as your only rights, and everything else is just second guessed, or the states will have control over everything else. There may be some truth in that. I mean, we talk all day long about the Second Amendment and the First Amendment, and people fight hard upon these amendments, but there's a lot of other rights and issues that are out there that kind of get disregarded, and maybe they're not as held to the value or to the civil liberties in the Bill of Rights. However, one other compromise is we're going to find out in the Bill of Rights, there's actually an amendment that says that if it's not in that just because it's not in the Bill of Rights doesn't mean you don't have other rights. So that allows for other interpretations. And that, again, that word interpretation is a big issue with this Constitution, the Bill of Rights. The problem with the Bill of Rights is it's written in 1787, it's ratified in 1791, and the way you thought and you said things in 1791 is different than the way you think in 2021. Okay? We're talking hundreds of years later. And the way we see the world is very different. So that causes what we have is called loose interpretations, and we have strict interpretations of the Constitution. And loose interpretations say that, no, these things need to evolve with time and it changes. And loose interpretations our constructivist, strict interpretations say, no, it says exactly what it means to say. Very much like fundamentalism versus more of a moderate interpretations of like religions. So we're going to get into this. First, we got to start with the process, though. How do you even amend the Constitution to get to the Bill of Rights? Because this is the first 10 amendments. It's kind of crazy to think there's 27 amendments, and 10 of them were done within 3 years of the Constitution. By 1791, 10 of them were in there. So we've only amended the Constitution 17 times since 1791. That's not a lot of changes. So we're going to find out, how do you actually change or amend the Constitution? Well, there's two ways. One we've actually done, the other one we haven't. So the first one is what all 27 amendments have ratified. So 2/3 of the House and the Senate in the federal government have to propose and approve the actual amendment. Okay? 2/3, so 67 out of 100 senators, and then 200 and something House of Representatives would have to vote this thing through. Then when it's passed the House and the Senate, it goes back to the states. 3/4 of the states must affirm the proposed amendment. So you're talking 40 states, almost 40 states have to actually okay this amendment after the House and the Senate approved it by 2/3. So it's really hard, it's a really tedious process to actually amend the Constitution. That's probably why it's only happened 17 times since the Bill of Rights. But it has happened. The new one is out there is the Equal Rights Amendment, the ERA. The Equal Rights Amendment is an amendment that women be treated equal under the law. Believe it or not, there's still nothing in the Constitution that says women are to be treated equal in the law, word for word. It's interpreted. It's interpreted under the 14th Amendment. We'll get into that, and that's your civil rights issues, because it's not in the Constitution as of yet. And that is actually being held up, I think, by 1 or 2 states. They can't get the second part, the 3/4 of it's passed the House and the Senate years ago in the 80s, but we need the 3/4 of the state to actually affirm it and to affirm the amendment, and that has not happened. There's only a couple states left that need to say yes, and it's done. So probably the 28th Amendment will be the Equal Rights Amendment or the ERA Amendment, and we'll talk about that later. Now, the other option, which has not happened, and this is even more complicated, is the Constitutional Convention be held with 2/3 of legislative states, and the convention can propose any amendments it deems necessary. Okay, so a Constitutional Convention has to happen. They have to come together and have a Constitutional Convention like they did in Pennsylvania. 2/3 of the legislators of the states have to come together. So Missouri State, Illinois, they have to come together and they have to pass this stuff. And those amendments must be approved by 3/4 of the states. So they have to propose it, pass it from a convention, and it goes back to the states. That is not how it's been done. It's actually never happened this way. It may happen someday. But one thing I want you to really pay attention to the amendment process is there is only one branch of government involved in the amendment process. That is the legislative branch. Article 1 is legislative branch. Article 2 is the executive. Article 3 is the judiciary. And now Article 5 tells us how to actually amend the Constitution. And they gave sole power to amend or change the Constitution to the legislative branch. It's not the president and it's not the judges that can change the Constitution. Only the legislative branch. Is it hard? It's super hard. It's happened 17 times in less than 200 years. It doesn't happen much, but it can happen. And it's almost all started with the federal government and then moved out to the state. So both the federal and the state legislators have to agree. It takes a huge majority, what I'd call a supermajority, 2/3, 3/4 of these groups to actually pass this thing through. Constitutional Convention could happen someday. I don't know. We'll see. All right, so let's look at the Bill of Rights. The Bill of Rights is the first 10 amendments to the Constitution. They're called your civil liberties. They establish and protect your individual rights from the governments and leaders in power, and it is your civil liberties. These are things that are written down clearly to be in the Constitution, that you have these rights. And there's James Madison, the father of the Constitution. And he was actually more the anti-federalist on this. He was more for the actual Bill of Rights. He thought that we should write some stuff down. Jefferson did as well. We talked about Hamilton on the other hand. He said, no, if you put this stuff in the Constitution, people are going to think these are the only rights. And we're going to have to list everything or other states won't take it serious. So these rights are your protected rights from the government, and they're still there today. And then you see Lady Liberties, this idea that it's the idea that the individual is protected from the state. In America, you have individual rights, your civil liberties. I want you to be clear on this. Your civil liberties are things that are actually in the Constitution, in the Bill of Rights, 1 through 10. If it's not in the Bill of Rights, it is not a civil liberty. It's probably a civil right. Things that have to do with the 14th Amendment are your civil rights, like equal treatment in schools, not being discriminated in the workplace. Those are civil rights. We talked about civil rights movement last year. Civil liberties would be things that are specifically in the Bill of Rights. Freedom of speech is a civil liberty. Freedom to express yourself, civil liberty. Freedom of press, civil liberty. Freedom of religion, civil liberty. Right to bear arms, civil liberty. Okay? So this is a kind of a difficult concept, but we'll go over it. And this is the key idea that comes out on how this can actually happen. It's a very important topic. It gets confusing to some students. It's called the legal doctrine of incorporation, or corporation doctrine, you'll see it called. But understand, it's the legal doctrine of corporation. The idea is that states that restrictions and demands that placed on federal government by the Bill of Rights apply selectively to the states as well, the 14th Amendment. Okay, so according to the 14th Amendment, anything that is in the Constitution, in the Bill of Rights, applies to the states, automatic. Okay, and if it's in the Bill of Rights or it's in the 14th Amendment, it applies automatically to the states. Okay. So I'm going to give you an example of selective incorporation. And this is a really important one. We'll talk about, we do civil rights. So selective corporation can be civil rights and civil liberties. So gay marriage is a civil right. It's not actually in the Constitution, the Bill of Rights, okay? But it's interpreted by the judiciary branch. The Judicial Supreme Court said, under the 14th Amendment, you have equal treatment under the law, and marriage, even though there's nothing about marriage in the Constitution, is a right that you are to be treated equal. So regardless of your sex or gender, you can marry who you want in America, okay? So once that happened in 2015, and it was Oberfeld versus Hodges, a very famous case, automatically the states have to incorporate this idea into their government. It has to become law. Their laws are, under the Supremacy Clause, it's over. And under the legal doctrine of incorporation, they have to do it. Does that make sense? So Missouri, so this caused a lot of problems, actually. Kentucky, remember there was a woman that was actually arrested. She refused to allow gay marriage in Kentucky in her county. She was an elected official. She went to jail because it's against the law for parts of Kentucky to be like, no, we're not going to enforce what the Supreme Court says in the law of the land under the 14th Amendment and civil rights. Also, it works the other way with civil liberties. Remember, civil liberties are your explicit enumerated rights in the actual Bill of Rights. So freedom of speech, under the legal doctrine of incorporation, it's not an argument. Alabama cannot limit freedom of speech that has been ruled by the Supreme Court as legal. So I'll give you an example. And then we actually had a problem with this in Missouri. So there's this guy that he put a big, ugly cross mark through the eminent domain. I don't know if you've ever seen it. It's on 55. He painted on the side of his house, right? And St. Louis City was really upset about this. They're like, that's against codes. You can't put a big X through eminent domain just because you're against eminent domain. It makes our house properties go down. It's right next to the highway. Everybody can see it. It's ugly. It makes the city look terrible. Went to court, got thrown out because under the Bill of Rights, it's covered under freedom of speech. If you want to write crazy things on your house, freedom of speech and the federal laws supersede local ordinances which say, no, you can't paint your house this color. If it's a freedom of speech issue, you can't. Now, if you're painting your house, you can't paint it because of some other reason. That might be under local laws or state or city laws. Not freedom of speech, though. You could write, I love Barack Obama on the front of your house. It's covered. And because of the legal doctrine of incorporation, even though states might have laws that say you can't do that, it's irrelevant. It is automatically incorporated into state law. It's automatic. It is the doctrine of the country. Okay? So civil liberties and civil rights have to be incorporated into states. They have to do it.